Hello, welcome back. GovDoc Breakdown, no opinions, just facts and summaries of government documents. And today we're back, June 18th, Supreme Court opinion, Oklahoma v. the EPA, Environmental Protection Agency. And this is a sausage alert, ladies and gentlemen. Sausage is being made, baby. This case addresses where legal challenges to certain Environmental Protection Agency actions should be heard under the Clean Air Act. Specifically, it deals with whether challenges to the EPA's disapproval of state plans, called State Implementation Plans or SIPs, for controlling air pollution should be reviewed in a regional court or the D.C. Circuit Court. Remember, cases involving federal agencies go straight to the Circuit Court, no district, right? So we got EPA, they're making a rule or a notice or a ruling, so challenges to that, straight to the district court. Or no, straight to the circuit court, no district court. District court, circuit court, Supreme Court, as we know. All right, background of the case here. In 2015, the EPA made the ozone standard stricter, which required states to submit new SIPs, state implementation plans, to comply. The EPA reviewed these plans and disapproved of 21 because they did not adequately address the good neighbor rule, which basically says you should be a good neighbor and not let your air pollution affect other states. So the EPA combined these 21 denials into one single national action and told states that any challenges to the decision would have to be heard in the D.C. Circuit Court because that is who takes care of cases with nationwide impact. Several states and industries challenged the EPA's disapprovals in regional courts, however, arguing that each state's SIP, State Implementation Plan, disapproval was a separate local issue. Regional courts around the country disagreed, which led to the Supreme Court case we discussed today, Oklahoma v. EPA. So one thing we need to know before we look at the decision, the Clean Air Act classifies actions as nationally applicable or locally/regionally applicable. So the Supreme Court here had to decide, are the EPA's disapprovals of Oklahoma's and Utah's SIPs nationally or locally regionally applicable? And two, if they are locally/regionally applicable, does the nationwide scope or effect exception apply, requiring challenges to go to the D.C. Circuit? So there's an exception to that rule saying if it's nationally applicable and affects the entire nation, then you have to go to the D.C. Circuit.
Full video located on our channel.